Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, January 26, 2022. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as our General Counsel, Mary Smith. I'm John Neerman. Today's meeting is a hybrid meeting, and most of the participants are joining us virtually, so please keep your microphones muted when you're not speaking. And for those of you who are making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. Where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to address, and we will do our best to accommodate your request. With that, I'd like to thank everyone for being present, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the application for the creation of Ellis County Municipal Utility District FM 984. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So, colleagues, as you know, the requests for hearings on mud creation are a little different than our typical hearing requests in that they're not subject to House Bill 801 and Senate Bill 709 requirements. What is required is this: requesters must file a timely hearing request that identifies a personal justiciable interest in the application and states how they will be affected in a manner different from the general public. They must also identify their location and distance to the regulated activity. There's no requirement to file comments. In addition, the Commission is not required to identify and refer specific issues to SOA, nor establish a hearing duration. And on this item, we have two requests, the City of Ellis and Ellis County. And I came out where the Executive Director and OPIC came out. I agree that both are entitled to a hearing. The petitioner's argument that the city has consented to the mud is an argument that they can make on the merits before SOA, but it does not impair the city's standing as an affected person. So I would grant the hearing requests and refer the matter both to SOA as well as to ADR. Commissioner Lindley, what do you think?
I agree.
Commissioner Janeka?
Likewise.
I think we're ready for a motion.
I've got one. I will, move that we grant the hearing request of the City of Ennis and Ellis County, that we refer the matter to SOA for a contested case hearing on the petition, and that we refer the matter to the Commission's Alternative Dispute Resolution Program concurrently with SOA's preliminary hearing scheduling process.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 2 is the consideration and hearing on a resolution from Walden Pond Freshwater Supply District of Kaufman County requesting the approval of additional drainage powers. The district has requested the approval of and should present the item, followed by any interested persons. Currently, I don't believe we have anyone signed in, the ED, and then OPIC. The Office of General Counsel recommends 5 minutes per party for presentations.
And is there someone from the district, the petitioner, on the line?
This is Scott Iman on behalf of the district. I can provide a little bit of background on this district.
Yeah, good morning. Please do. Thank you for joining us.
Sure. Good morning to you. This district is 429 acres. It's located east of Dallas. It was created by the Commissioners Court in November of 2018. Later, the district converted to a freshwater supply district for road powers. And with that conversion, we'd like to make sure that we have the drainage powers in place. So the district has filed this application under Rule 293.15. And I'm happy to answer any questions.
Great. Thank you, sir. Appreciate that explanation. I have no questions. Commissioner Lindley?
No questions.
Commissioner Janeka?
Likewise.
All right. No questions, sir. So thank you for that. And we'll hear next from the Executive Director.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Kayla Murray, and I'm an attorney with the TCQ Environmental Law Division, representing the Executive Director. With me is Andrew Painter from the District Section. The Commission received an application from Walden Pond Freshwater Supply District of Kaufman County requesting the approval of additional powers to provide drainage services as provided in Texas Water Code Sections 51331 and 332 and 30 Texas Administrative Code Section 29315. Based on a review of the application and supporting documents, the district's request to include drainage services is feasible and practicable, will benefit the land, and will further public welfare. Therefore, the ED requests that the Commission issue an order granting the district's request for additional powers to provide drainage services. Thank you, and we are available to answer any questions you may have.
Thank you, Ms. Murray. I have none. Commissioner Lindley?
No?
Commissioner Janeka?
None, thanks.
All right. And just to confirm, no one had signed in to speak on this item?
That's correct.
Okay. And let's hear next from the Office of Public Interest Counsel. Good morning, Mr. McWhirter.
Good morning. OPIC recommends granting the request of Walden Pond Freshwater Supply District of Kaufman County for additional powers to provide drainage. We support issuance of the proposed order as presented by the Executive Director.
Thank you for that. Colleagues, I agree. It appears to me that the district has met all of the legal requirements to be entitled to the additional powers that it requests. In addition, this authority appears to be economically feasible and in the best interest of the district. Notice appears to be proper. The proposed order appears to meet all the minimum legal requirements. So I'm ready to grant the request.
I agree.
Commissioner Lindley?
Likewise, I will make the motion that we grant the request by Walden Pond Freshwater Supply District of Kaufman County for approval of additional drainage powers and issue the Executive Director's proposed order.
A second?
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 3 is the consideration of an administrative order for the Ballard Pit State Superfund site. The ED is the moving party and should present the matter, followed by any interested persons, and finally, OPIC. The Office of General Counsel recommends 5 minutes per party for presentations, and the Executive Director's staff is here to present.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Cullen McMorrow with the Litigation Division. With me are Scott Sedemeyer and Sharon Barker of the Remediation Division. This is an administrative order to conduct remedial activities for the Ballard Pit State Superfund site located near Robstown in Nueces County, Texas. As part of the state Superfund process, TCEQ has completed its investigation of the site as well as performed several removal actions. The groundwater at the site is contaminated with total petroleum hydrocarbons and a non-aqueous phase liquid plume. After appropriate notice and opportunity to comment in accordance with Texas Risk Reduction Program rules, the Executive Director selected the remedy of an on-site and off-site plume management zone that will prevent access to the contaminated groundwater plume and the NAPL plume through the use of institutional controls. The remedy includes long-term data collection and analysis to monitor the plume and ensure its stability. Potentially responsible parties named in the order were given an opportunity to fund or conduct remedial activities at the site. No good faith offers were received. Therefore, there are no agreeing respondents. The Executive Director respectfully requests that the Commission issue the administrative order pursuant to Chapter 361 of the Texas Health and Safety Code. We are available to answer any questions you may have and would like to reserve the remainder of our time for rebuttal if necessary.
Thank you, Mr. McMurrow. I have none. Commissioner Lindley, any questions?
No?
Commissioner Janeka?
No, I'll hold off on connecting the dots to the end. It's not a question for staff, so good.
Great.
Now, thanks.
Okay, and Ms. Smith, is anyone signed in to speak on this item?
No.
All right, and Mr. McWhirter, what's your analysis?
OPIC recommends the Commission issue the order regarding the selected remedy for this site as presented by the Executive Director.
Thank you, and I agree with that, colleagues. We're dealing here with some remaining groundwater contamination following the removal actions. The order before us identifies the responsible parties and selects the remedial actions, which consist of a plume management zone with institutional controls and certain other contingencies. The Executive Director's analysis and recommendations appear to be appropriate. The executive director has met the various notice requirements. The proposed order appears to meet all the requirements under Chapter 361. As we heard, there were no good faith offers to perform the remediation by the responsible parties. We received no comments during the comment period or at the public meeting. I think we've checked all the boxes to go ahead and move forward with this.
I agree.
I too am in agreement, and I'll only add one final thought, and that's just to make the observation that this matter involves an issue we have flagged for our discussion with Sunset, and I'm pleased that I remain pleased that staff has chose to pursue that issue in the broader context of discussions we're engaged in as we evaluate ourselves and facilitate the Sunset Advisory Commission evaluating us. The analysis here was tied to our current practice of lowest cost to the state, and that standard isn't always the one that the state uses in purchasing or in acquisitions. It's best value, and that may not be the lowest price. I see that we've evaluated those three options on price and I think on efficacy of remediation, and I don't think that that suggests any changes for the analysis on this item, but I do appreciate and just wanted to acknowledge and point out the moving pieces. I'm glad that we're continuing to look at this, and I look forward to see if executive director staff find further opportunities to benefit the state and the public in reaching for best value rather than being constrained to the lowest price. But happy to move forward today.
Great. Thanks for that comment. I think we are ready for a motion.
I will move that we adopt the executive director's proposed administrative order concerning the Ballard Pitts State Superfund site.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 4 is an amendment without renewal of general permit TXR 150000, authorizing the discharge of stormwater from regulated construction activities. The executive director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Entrance Counsel. On behalf of the Executive Director, I'm Michaela Coleman, representing the Water Quality Division. With me today is Rebecca L. Villalba with the Water Quality Division and Kathy Humphreys with the Environmental Law Division. Staff requests adoption of an amendment without renewal of Texas Pollutant Discharge Elimination System General Permit Number TXR 150000, which authorizes stormwater discharges from construction activities into surface water in the state. The purpose of the amendment is to expand the applicability of the general permit to include non-exempt stormwater discharges into surface water in the state from construction activities associated with oil and gas exploration, production, processing, or treatment or transmission facilities, and to replace the 2017 Environmental Protection Agency or EPA issued National Pollutant Discharge Elimination System Construction General Permit number TXR 10 F as in Frank 000, modified June 27 of 2019. The amendment is in response to the transfer of state and federal regulatory authority to the Texas Commission on Environmental Quality for discharges associated with oil and gas exploration, production, processing, or treatment or transmission facilities into surface water in the state that occurred on January 15, 2021, following the implementation of House Bill 2771 from the 86th Texas Legislative Session in 2019. Public notice of the draft permit was published in the Houston Chronicle newspaper and the Texas Register on September 24, 2021. Public comments were received and a response to comments was developed, which is included in the backup material before you today. Staff recommends adoption of this general permit. Additionally, staff requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Coleman. I have none. Commissioner Lindley?
No questions, thanks.
Commissioner Janeka?
No questions, but thank you, ED staff. I was pleased on the responses to comments on this item. I thought they were very helpful and specific.
Agreed. Ms. Smith, has anyone signed in to speak?
And no one signed in on this one.
Okay. And what says the Office of Public Interest?
OPIC recommends adoption of the amended construction stormwater general permit as presented by the executive director.
Thank you, Mr. McWhirter. Colleagues, as Ms. Coleman explained, the proposed amendment is really a continuation of our implementation of House Bill 2771, following the delegation to TCEQ of the authority to issue discharge permits for produced waters. And there was ample public participation. I think staff adequately addressed the salient issues, so I'm ready to move forward.
As am I, but I will make a motion. I will move that we adopt the amendment to general permit number TXR 150000 as recommended by the executive director and adopt the executive director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
That brings us to our enforcement docket, items 5 through 34. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. Can you hear me?
Loud and clear. Go ahead.
Thank you. Sorry. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 34. The total assessed administrative penalties are $487,047, with $100,134 deferred, $94,780 applied for supplemental environmental projects, and $292,133 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley?
No questions?
Commissioner Janeka?
None, thank you.
Is anyone signed in to speak, Ms. Smith?
On items 5, 6, 7, and 10, we have individuals who have signed in and indicated that they don't wish to speak unless the commission has questions, and their presence will be noted for the record.
Thank you, and we do appreciate their presence as well. We'll turn next to the Office of Public Interest Counsel. Mr. McWhirter, what's your take?
My office reviewed these items, and we recommend approval of the proposed orders as presented by the executive director.
Thank you. Colleagues, I agree. I'm ready to move forward with this docket.
Me too.
Likewise, I will make the motion that we adopt items 5 through 34 as recommended today by the executive director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 35 is consideration of the monthly enforcement report, and the executive director's staff is here to present.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal years 2022 through November. There were 333 effective administrative orders issued, and of those, 46 contained supplemental environmental projects. These orders assessed a total of $4,360,761 in penalties, with a payable amount of $2,644,794. $1,054,222 are to be paid towards supplemental environmental projects. 3,306 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 566 enforcement action referrals have been received. There are 1,731 pending administrative orders with 324 cases that are on the backlog. 193 cases are pending at the Attorney General's Office for representation in district court, and 5 judgments have been issued. 2,128 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2020, 2021, and 2022. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Thank you for the report.
And Ms. Smith, has anyone signed in to speak?
No one signed in.
And Mr. McWhirter, what do you think?
I don't have any questions. I appreciate the report.
Likewise, and colleagues, there's no action necessary on this item, so I'll ask Ms. Smith to please call the next item.
Item 36 is the consideration of the withdrawal from the U.S. EPA's review of the November 2016 Supplemental Implementation Plan revision made in response to EPA's 2015 Startup, Shutdown, and Malfunction SIP call. The Executive Director's staff is here to present the item.
Good morning, Mr. Pritzloff.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Craig Pritzloff, Director of the Office of Compliance and Enforcement. With me is Betsy Petcoles with the Environmental Law Division, Elizabeth Lieberknecht with the Litigation Division, Cynthia Gandy with the Coastal and East Texas area, and Keith Sheedy with the Program Support Environmental Assistance Division. This action is the proposed withdrawal of a November 2016 State Implementation Plan revision made in response to United States Environmental Protection Agency's 2015 Startup, Shutdown, and Malfunction SIP call, or SSM SIP call. For background, on June 15, 2015, EPA issued a final action in response to a petition in court filed by certain groups. In that action, EPA rescinded a long-standing interpretation dating back to at least 1999 that the Clean Air Act permits states to create narrowly tailored affirmative defense provisions in their state implementation plans for certain excess emissions. The new interpretation limited affirmative defense provisions in state implementation plans. The SIP call was issued despite Texas's affirmative defense provisions, which are set forth in 30 Texas Administrative Code 101.222, having been previously approved by EPA in 2010 and upheld by the Fifth Circuit Court of Appeals, in which EPA defended its determination. In response to the SIP call, on November 2, 2016, the TCEQ adopted amendments to its affirmative defense rules. Those amendments are at 30 Texas Administrative Code 101.222 K and L. Subsection K confirmed that TCEQ's affirmative defense provisions are not intended to limit a federal court's jurisdiction or discretion to determine the appropriate remedy in an enforcement action, and that the provision of K shall not apply until legal appeals have ended. On November 18, 2016, the TCEQ submitted this SIP revision to EPA. To date, EPA has taken no action on this submittal. However, on February 7, 2020, EPA published a new final action, which withdrew the 2015 SIP call issued to Texas, and they issued a new policy memo confirming that states may create narrowly tailored affirmative defense provisions in SIPs for certain excess emissions. Because that SIP call as to Texas was withdrawn, there is no longer an obligation to submit a new state implementation plan revision in response to the 2015 SIP call. Therefore, staff respectfully recommends that the 2016 state implementation plan revision responding to that 2015 SIP call be withdrawn. If the new final action concerning this issue is published, staff will review that action and respond accordingly. The TCEQ rule provisions at 30 Texas Administrative Code 101.222 K and L will remain in effect. Thank you, Commissioners. We are available to answer any questions.
Thank you, Mr. Pritzloff. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka?
No questions. Thank you.
All right. Well, as we heard, this submittal was in response to a SIP call that EPA issued and has since withdrawn. It no longer serves any legal purpose, but it only serves to add to the backlog, the EPA SIP backlog. So I do think it makes sense to withdraw it. And General Counsel has reminded me that I missed Mr. McWhorter. So before I go any further and we vote, let's hear from our Public Interest Counsel. Mr. McWhorter, what's your take?
Yes, sir. I think we are on the same page. OPIC agrees with the Executive Director that the 2016 State Implementation Plan revision is no longer needed because EPA has withdrawn its 2015 SIP call. We recommend withdrawal of this SIP revision as proposed by the Executive Director.
Thank you, Mr. McWhorter, and thank you, Ms. Smith. Colleagues, that I think tees it up pretty nicely. Any additional thoughts, or should we hear a motion?
No, I have a motion. Okay, I will move that we approve the withdrawal from the United States Environmental Protection Agency's review of the State Implementation Plan revision submitted on November 18, 2016, made in response to EPA's 2015 Startup, Shutdown, and Malfunction SIP call as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item 37 is consideration of agency post-incident response actions related to the February 2021 severe winter storm, including plans to evaluate factors that impacted public water system response and recovery actions. The ED's staff is here to present the matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Brittany Wortham-Teakle, Manager of the Emergency Preparedness and Response Section in the Water Supply Division. With me today is Carrie Michelle LaKyle, Deputy Director of the Water Supply Division. I am here to provide an update for the agency's after-action review of Winter Storm Uri. During the last 2 months, the project team has been conducting work sessions to begin formulating our recommendations based on what was learned during the roundtable discussions that occurred over last summer, the public water system survey responses, and research into what other states do to enhance and integrate critical infrastructure resilience. One of the most universal topics discussed by stakeholders has been the request for additional training and guidance for emergency preparedness. Throughout this project, the project team members have continued to coordinate, develop, and promote multiple training opportunities made available through both virtual and in-person platforms for developing emergency preparedness plans, as well as addressing general and power resiliency topics. The stakeholders' repeated requests for additional training and guidance are also being integrated into our recommendations to address many of their questions and concerns. The Water Supply Division recently restructured in September to create a new emergency preparedness and response section so that we can also address the immediate needs for training, emergency response during a disaster, provide guidance for system resiliency, and assist with the development of emergency preparedness plans. As we move into the final phase of our project, the team is currently seeking feedback from other areas of the agency that may be impacted by the proposed recommendations. Once that has been completed, we will be prepared to present our proposed recommendations for your consideration. This concludes our update, and we are available for any questions you might have.
I have none. Thank you, Ms. Wortham-Teagle, for the report. Commissioner Lindley, any questions?
One question, I guess. I appreciate the reports. I know y'all been very busy. I guess my only question would be, what's the timing? When will we see the report or get the report? And not trying to rush it, just curious what the timing is of that.
As of right now, we are on track with meeting the timelines we laid out at the March 31 agenda for approximately 1 year, and we've been meeting our milestones in that project plan so far.
Okay, thanks.
Great. Thank you, Commissioner Lindley. Commissioner Janeka, any questions?
Lots of questions that I don't know they're appropriate or we're able to go into today. I was able to participate in the latest meeting of the Texas Energy Reliability Council on your behalf, as we're assigned membership now in statute. I think that discussion is moving in parallel to this one, and I'm really pleased with where we're at as an agency. And I think that they will bring a lot of great new improvements in mapping out our power and natural gas infrastructure. And I think that where our water infrastructure overlaps or connects is the next logical step. So I'm pleased that we're taking our time on evaluating these issues, and we'll be ready to provide them our input and detailed information when they're ready for it. So thank you for your efforts.
Thank you, Commissioner Janeka. Ms. Smith, has anyone signed in to speak?
No.
And Mr. McWhorter, would you like to share your thoughts with us?
I appreciate the report. I don't have any questions. Thanks.
Thank you, Mr. McWhorter. Again, I do appreciate the report. There's no action necessary on this item, so Ms. Smith, I'll ask you to please call the next items.
The next items are for executive session, and the commission will meet in closed session in Building E, Room 211S, at, should we just say 10 o'clock?
Yes.
At 10 o'clock. As permitted by the Open Meetings Act, including Texas Government Code, Section 551.071 and 551.074, to take up and consider matters pursuant to items number 38 through 41 as posted and noticed.
With that, the time is 10 o'clock and we are adjourned. Forgive me, we are not adjourned. We stand in recess.
The commission met in room 211S of Building E for closed session from 10:07 a.m. until 10:12 a.m. on item number 40 as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. The agenda stands adjourned. The time is 10:16.